In 2017, the government brought in new legislation which involved corporates having to put into place procedures to avoid their employees from facilitating tax evasion. It's pretty broad legislation which applies to a lot of companies and partnerships in the UK. As a consequence of a company falling foul of this legislation, it will be subject to substantial fines and possibly regulatory action.
Corporates have to comply with this piece of legislation, and their only defence in court would be that they have reasonable procedures in place. Given the timeframes in place, it's essential that corporates act now so they can comply with the legislation. However, the way it's been drafted means that all corporates get brought into scope, and therefore everyone needs to do something to ensure they are compliant. Furthermore, the Act actually has two aspects to it, a UK tax evasion offence and a foreign tax evasion offence. And although there are some complexities involved in that, it means that organisations that have international operations will also need to look at this carefully.
Given the legislation now being live and obviously right in front of them, need to ensure that they're aware of it, that the board or the senior partner group are aware of it and are committed to doing something about it. The business needs to do a risk assessment to find out where in its business it is strong or it has weaknesses and have plans of what it's going to do about that. It needs to communicate the message from the top of the business down through the business itself to its employees and any contractors or agents that work with it.
There are a number of steps that an organisation needs to work through. The first of these is looking at who your associated persons are. Then the organisation always needs to stand in the shoes of those associated persons and look at what the opportunity, motive and means for facilitation of tax evasion is. Opportunity is where could that tax evasion arise. Motive is why the facilitation of tax evasion could arise. Often that can be financial. And then means is how the tax evasion could arise. And once an organisation has looked at those risks, it can prioritise those, identify what the high risks are, and start planning those reasonable procedures to ensure those controls are in place to enable it to be compliant with the new legislation. A common question we're getting asked is, who should own it? Should it be finance? Should it be tax? Should it be legal? Should it be compliance? And really, it depends on your organisation. You probably need contributions from all of those different areas of the organisation to enable compliance, but making sure that people are focused on it and there's senior leadership buy-in to drive forward the process. Our clients are asking Smith & Williamson to help in a number of different ways. Firstly, the important step of undertaking the risk assessment. We're helping in two distinct ways. Firstly, undertaking the risk assessment in full in conjunction with the organisation's staff. Then secondly, we provide a template to the organisation for them to complete their risk assessment, which we can then review and ensure that it is compliant with what HMRC would expect and also in line with other similar organisations. In addition, we can help with training of key staff, communication around the whole organisation, alerting them to the new piece of legislation, and then finally around board minutes so that senior leadership is aware of the new piece of legislation.
This piece of legislation, it's very broad and it's very significant. It is not something that any corporate entity or partnership within the UK and indeed overseas that does business in the UK can ignore.